Hey everyone. Sorry we didn't get to meet live. It happens. Sometimes screencasts work better. Everybody has busy lives. I am a one take girl. That means that I'm not going through an editorial process with this video. It is what it is. I don't get to take it back and do it over again in the classroom. So this is very much the same thing. I'm going to take about 10 minutes and talk with you about the process of writing the internal memorandum of law and of course welcome you to ask any questions that you might have on the question and answer board for the memo of law. In the particular video you'll actually see my mouse move. If there's anything important that I want to point out to you, I will use the mouse as a pointing device and you should be able to see it. So the first thing is, who's the audience for the internal memorandum of law? Well, since it's an internal memo, it's really the attorney that's going to be at least the primary audience for this particular memo. This is a memo that would often be housed in a case file, something that's retained in the client's file. This is going to be doing some prediction. The type of memo that would really lead the attorney to conclude whether or not he or she would like to actually take the client's case. Now, the attorney is not necessarily the only audience member for this particular memo. The potential client may see it, and in addition, the memo would likely form the foundation of any other writing that comes on later on in the case, should it be required. The format of the memo is pretty straightforward. There are a few different types of formats, and of course, a law firm can certainly designate their own peculiar, by that I mean not odd, but unique format. But most cases, the format of the memo will have five sections: the heading, the facts section, the issue section, the discussion, and ultimately a conclusion. And that's when I'm anticipating that you will hand in to me a memo with at least those five sections. So, in order to prepare for the memo, you would obviously need to be abreast of what is going on with the client. The paralegal may have been part of the interview process with the client. The paralegal should be familiar with the client's case. The paralegal would then complete any legal research that was necessary to write the memo to understand what was going on in the client's case in an objective way. The particular assignment that you are doing is something called a closed assignment. That means you are not doing any legal research, not at this time. At some point in the future, you'll be doing legal research on these same facts. But today, you are limited to the 10 cases that I've given you and the statute. You would then read the cases and, of course, take notes on or brief those cases. You've done one case brief for grade, you've gotten comments back at this point. But if you brief additional cases, or you should really be briefing additional cases, not so much for a grade, but to facilitate the process of writing the memo. A memo section in the discussion section is organized by IRAC. So I seem to recall at some point when we were talking about briefs, folks saying that they were using IRAC to write briefs. And not usually the case. Briefs are usually written in such a way where IRAC is not required. IRAC is an organizational tool that organizes the discussion section of the memo, and a little bit later on we'll adjust it and call it CRAC, conclusion, rule, analysis, conclusion, for a persuasive document and an argument section. For now, the issue, rule, analysis, conclusion is the formula that we will use to write the discussion section. And it is the foundation of most well written legal documents. There is an expectation that IRAC would be used when organizing a discussion section. So we don't want to leave the judge to find that that expectation is not met, or the attorney to find that that expectation is not met. Legal writing is very formulaic writing. It is not creative writing. The more you do it the way it's anticipated or expected, the better off you are. The less you do what is expected, the more you kind of invent your own way or figure out what feels good for you, the less meaningful the document may be to the reader, because the reader is expecting writing in a certain way. So here's an example of IRAC where the different colors show you what has been written. It's a very basic analysis. Now, this IRAC is a paragraph. IRAC can certainly be longer than that, but this one is a paragraph. So the issue here is the first sentence. Force is a final element of the offense. The rule is in pink. The defendant must have used force or the threat of force in order to be convicted of robbery. And typically, a rule would have some sort of citation for the principle because remember, the rule is the rule of law. The analysis here in green. Smith's statement that Jones would regret it if he denied Smith's demand for money was an implicit threat of force. Now, you have a snapshot of some writing, but Smith is the first. This is the first time you've heard about somebody named Smith. And this is the first time that you've heard somebody named Jones. What you see in the analysis section is a synthesis. So, what we have is a rule of law. That rule of law doesn't come from the situation between Smith and Jones, but comes from a case or from common law or from statutory law. And then we see the facts of Smith's case or Smith and Jones's case. So the analysis is the factual underpinning. We're bringing the facts in. The conclusion then is the combination of the rule and the facts, or something that attorneys might call a synthesis. Smith's actions therefore meet the force requirement, and that's in black. And so that is a good example of an IROC structure. One of the ways in which I suggest that students learn IRAC is to go in the textbook. And for figure, I believe it's 12.1, that is the sample memorandum of law, to actually go through and annotate the discussion section. Find each IRAC. So for each issue, write an I in the margin, and for each rule, write an R, and for each analysis, write an A, and each conclusion, write a C. Or I know many of you are doing highlighting because I see that in the threads. So you can go through and highlight those things and practice finding those components. I guarantee you will because it's the foundation of all good legal writing. And then that will help you actually to develop your own writing skills using IRAC. So the memo organization then would be the heading. To from date read. A statement of facts. I think I've shared with you very early on in the course. I like the TARP facts, the things, the actions, the relief, and the parties. Those are the important things in my estimation. And in the memo, you will include any relevant procedure in the facts itself. Not a lot of procedure going on here because this is not a case brief, but we don't need a judicial history section or procedural posture section because it's not a case brief. Then comes the issue. The issue is stated in the form of the question. The question should be able to be answered yes or no. Do not, I repeat, do not be afraid of facts. The number one most common mistake in an issue statement is that students just kind of leave out facts. And what that means is that that issue statement can be cookie cuttered to the next case and to the next case without any changes, and it still means the same thing. And if that's true, if you can write the same issue statement and have it apply to 5 different cases, it's not specific enough. So use the under does when format. That would really be helpful. And then you get to this discussion section. Remember, you're going to be using IRAC throughout, and it is entirely possible that issues can be broken into sub-issues. Certainly, the sample memo in the textbook is broken up in that way, and you can go ahead and use IRAC in that particular type of analysis and use sub-issues then under the issue section of IRAC as it's outlined here. And then, of course, there is the conclusion, which is a summary of what you believe the outcome of the case will be. So, Wendy, I believe, asked the question in the discussion board, and I said I would address it when we met in live, but we didn't, so I'm going to address it here. And she says, wanted to throw a question into the discussion. All of these cases have an awful lot of medical jargon in them that only a doctor would understand, yet they seem pertinent to demonstrating credible objective medical evidence to establish a case of serious injury. To what degree would one summarize these in a memorandum of law? How important are the details within the diagnoses? And are there any tips for highlighting them when they're relevant without getting bogged down in them? Well, there is a great Westlaw article or ad, I should say, that goes back a little ways, and it depicted a whole bunch of one person with a whole bunch of different professions. So, at one point they were dressed as a construction worker, another point they were dressed as a nurse, another person point they were dressed as a firefighter, and so on and so on and so on. You get the picture, and it was the same person. It was all the lawyer, right? The lawyer gets to wear all those hats because the lawyer and through the lawyer, the paralegal has to understand the facts of the case, just like they have to understand the law of the case. You're not going to be able to win a case if you don't understand its facts. It's just that simple. So, yes, you do have to learn an awful lot of medical jargon. And in fact, it may be true that only a doctor would understand it to the depth that a doctor would, but the lawyer and in fact the paralegal will understand that jargon fairly well by the time they take a case like this to trial. They'll understand the medical issues fairly well. You can't cross-examine a doctor or examine a doctor without understanding the medical issues. And the paralegal would be in charge of dealing very much with many of the medical records in the type of law firm that would take this type of case. And so the paralegal probably knows tons about the medical case in this sort of instance when he or she is doing regular work in this area. That said, for this purpose, because you're not going to be able to understand the medical issues to that kind of depth in 14 weeks, what you will need to do is pick up on the parallels in the medical issues. So I think I just posted on a discussion board in answer to another question. If the fact that the client has a spasm at a certain time or in a certain location, it becomes relevant if what you see in one of the 10 cases that you're reading, a judicial discussion of the type of spasm and the time frame of a spasm that a particular person has. And if that's the case, then you know that the fact that your client has a spasm is relevant if the judge's decision in the case that you're reading relies on the fact that that particular plaintiff had a spasm. So you know to put the spasm in the facts. Now, if it's just a spasm that is articulated by the judge in the case that you're reading that the plaintiff had suffered from, then all you do is put information about a spasm. However, if the judge says that it is a lower back spasm, then the location of your client's spasm might become relevant. If it is a persistent lower back spasm that occurs more than 1 year post accident, then if your client's time frame is known, the time frame of the spasm then becomes relevant. And so that's the detail that you need to pick up. The detail becomes relevant to the extent that the case law tells you that it's relevant. So be guided by the case law. So I hope that really helps in answering this question. Be happy to answer any of the questions that you have either on the discussion board or if you prefer a screencast or even just the voice answer because I can do that on the discussion board as well. Let me know. I hope you're doing well and I'm traveling the next few days. I'll be in Philadelphia presenting at a conference. I'm presenting one, two, three times actually at that conference. Looking forward to it like crazy. But make sure to connect with me if you need anything because I've got my computer with me. Have online class. We'll travel. All right. Hope you enjoyed it. Bye.